Asaf here, employment attorney here in Los Angeles, California. Today's topic that I'm going to be speaking about and explaining is the Families First Coronavirus Response Act, and specifically the Family Medical Leave Expansion as it relates to the FFCRA, the Families First Coronavirus Response Act. This particular expansion, though it's helpful, it's quite limited. It actually only is for individuals who are going to be using FMLA leave and the expanded version of FMLA leave to care for their child who's under the 18, because the place of care or the school or what have you has now been closed due to COVID-19. So what I'm going to first do is go through a very brief overview of what the FMLA is and normally how it works and what kinds of reasons you can go out on leave for that, and then go into how this particular expansion expands that and who it affects and who it can help. And hopefully this is useful to some employees that are looking to use this for some kind of leave or payment. Now, the FMLA prior to COVID-19 would allow eligible employees to take up to 12 weeks of protected unpaid leave, that's the key word here, for certain family medical reasons. I'm not going to go through all of the reasons or examples of how someone could take an FMLA leave, but some examples would include, for example, to deal with a serious health condition for the employee themselves, a serious health condition for the employee's immediate family member, for the birth of a child, or for bonding time with a newborn or recently placed child with the employee, for example, if the employee adopted a child. And the FMLA only applies to certain employers. It would apply to all public sector employees. So if you're in federal, state, or local municipality of some sort, you would be covered. Or if you're a private sector employee with 50 or more employees, and that's a key part here, because this is something that's been expanded on, and I'll get to that later. In order to be eligible for FMLA leave before COVID-19, you have to have worked for the employer for the employee would have to have worked for the employer for at least 12 months, and would have to accumulated or worked for at least 1,250 hours over the previous 12 months. In addition to that, the requirement is that they have to work at a location where there is at least 50 employees that are employed by the employer within 75 miles. So in order to be able to take FMLA leave, there are some requirements. Now, the way that the FFCRA expands the FMLA for this particular reason is, first of all, it's going to do away with the 50 or more employee in a 75-mile radius requirement. This particular expansion applies to any employee who works for an employer that has 500 or fewer employees. And moreover, they don't have to have worked for the employer for 12 months or accumulated a certain number of hours. The only requirement is that they have been employed for at least 30 days, okay? And this particular expansion is effective starting April 1st, 2020, and is set to expire December 31st, 2020. This may change. Everything is in flux right now, as I've mentioned before, and no one knows if it's going to be expanded, it's going to be shortened or not. But as of today, as of April 15th, 2020, this is where this stands. Now, the way that the FFCRA expands the FMLA is for a very limited reason. It's not going to allow an individual to take leave, for example, because of their own health condition under FMLA and negate the requirements. It's only for this particular reason, and that reason is if the employee is unable to work or telework due to a need for leave to care for a child under 18 years of age, if school or place of care has been closed, or if child care is unavailable due to a COVID-19 reason. So this is the only reason that this particular the FMLA is expanded. It's for this reason only. So if the individual wanted to take leave for their own health condition and had only worked there, for example, for 30 days, or for an employer that has 40 employees, for example, then they couldn't do that. The only way that they could fall under the expansion is for this particular reason, which is for childcare. The way that this particular expansion works, or what the major benefit of this expansion is that it allows the FMLA leave to be paid as opposed to unpaid. Normally, FMLA leave is unpaid, and it just provides the employee with job protection. In this situation, the FMLA now, if the employee is going to go on leave to care for a child that's under 18 years of age due to a COVID-19 reason where childcare is unavailable, will now be paid up to 12 weeks. And for weeks 1 and 2, it's going to be unpaid, but that's because, as explained in the previous video blog that I did, the employee can choose to use the FFCRA's employee paid leave or emergency paid leave, which would pay for 2 weeks of that employee's salary up to $200 a day, or I believe it would be then $2,000 in the aggregate. Or if they wanted to not exercise that, they could use paid sick leave, PTO, or whatnot. The paid portion of this leave kicks in from weeks 3 through 12, and it's similar to what was discussed with respect to the employee paid leave. The employee should be paid for 2/3 of their regular rate of pay, but that is capped at $200 per day, or $10,000 in the aggregate. So even if an employee earns much more than $200 a day, that's the maximum they're going to be able to get, and it has a limit on it. Now, this particular expansion to the Act also has an exemption for certain employers. Once again, employers of healthcare providers or first responders, they can choose to exempt themselves, and that's what that has been happening. A lot of them have, because it's tough for them. Moreover, if there is, just similar to the Emergency Paid Leave Act or the Employee Paid Leave Act under the FFCRA, if there is an employer that has employs less than 50 employees, they can seek an exemption if offering this particular paid leave would jeopardize the viability of the small business, and that's an election that they'd have to make. So it's possible that if an individual is working for an employer with 50 or less employees, they may not be able to take advantage of this as well. Now, there also is something to be cognizant of, which is the overlap issues with the FMLA. So the FMLA and the COVID-19 expanded FMLA don't allow an employee to combine leave benefits. So what that means is that the total leave under the FMLA or the expansion is 12 weeks, regardless of how it's used. So for example, if an employee were to use 7 weeks to care for a child under this expansion, then going forward under the FMLA, they would only have 5 weeks left. They don't necessarily get to double dip and have 12 weeks for this or 12 weeks for that. Moreover, and this hasn't been tested yet, but the way I interpret this in the way that the act is written is that if the employee has previously exhausted their FMLA leave within the 12-month period, the employee may not be eligible for the expansion or the paid leave under this act. So this was just a video just to explain this particular expansion. It's not a huge one. It's limited only for individuals who have children and are unable to find childcare. But I hope that you found this helpful, and if you have any questions, please feel free to reach out. And if there are other topics that are related to employment law with respect to COVID-19, and specifically within California, because that's where I'm licensed to practice, I would be happy to try to do a video blog about that. Thank you and have a great day.